Before we going into the details or the substance of international environmental law or environmental law instruments, let's first have a brief overview of what are the legal developments in the historical context. When did this environmental law begin, or what was the context in which this development of environmental law started, or whether the development of environmental law, whether international environmental law is a recent phenomenon, or it has been already it has already been there ever since the human civilization started. But many of the standard textbooks on international environmental law, they cites mid 19th century as the major sources of development of what we can call as modern international environmental law. So in that context, some of the early developments has focused on conservation of wildlife. For example, Convention between France and Great Britain relating to fisheries 1867, Convention for the regulation of whaling 1931, Convention to protect birds useful to agriculture 1902. So these are the few examples of international environmental law in the early historic context. But when we look at some of these instruments, it's quite clear that these instruments followed a piecemeal approach. When I say piecemeal approach, because look at the focus of these instruments. All these instruments essentially focus on some minor part of the environmental issue, say for example conservation of wildlife. Or if you look at the third example, Convention to protect birds useful to agriculture 1902, and this is all about protection of birds useful to agriculture. So that means essentially the developments in the early period was following a piecemeal approach. It never followed a comprehensive approach addressing all kinds of environmental issues. It never seemed to have accepted or recognized the essential link between different species and environment. So in that way, this was a kind of limitation of environmental law or environmental law in its early period. But later on, another major landmark in the historical context is what we know as Trail Smelter case. This was a case between Canada and United States, and this arbitration case was decided in 1941. And this case was about fumes emerged from or escaped from a smelting industry in Canada, and it caused some damages in Washington in the United States. So the question was, what kind of liability can be fixed on the industry, or to put in a different way, what kind of liability can be put on Canada for what they caused as environmental damages. And this is considered as a landmark case. Arguably this is an important case where an arbitration tribunal introduced this concept called state responsibility in the context of transboundary pollution. And let me just read out an important paragraph from this Trail Smelter case, because in this case the tribunal held that, no, I quote, "No state has the right to use or permit the use of its territory in such a manner as to cause injury by fumes in or to the territory of another, or the properties or persons therein, when the case is of serious consequences and the injury is established by clear and convincing evidences." There are a couple of points to be emphasized from this case. First, it clearly lays down a rule that no country has the right to cause injury to persons or property in another country, and if it happens, that particular country is liable under international law for such environmental problems. So to conceptualize this is a case laying down an important rule on the state responsibility in the context of transboundary pollution. And the reason why this case is considered as landmark, because this principle of state responsibility in the context of transboundary pollution has found its way in several documents adopted subsequent to this case. And this principle was followed by various courts and tribunals, including the International Court of Justice in various cases. So in that way, we can safely conclude that the Trail Smelter case and its principle of state responsibility in the context of transboundary pollution had great influence on the subsequent development of international environmental law. So while these are the few landmarks, what we have seen in the last few decades, especially since 1970s, is a dramatic or rampant dramatic expansion of international environmental law, especially since the Stockholm Environmental Conference 1972, that we will discuss a little more in detail. So before going into that, let's have another major part, like what are the sources of international environmental law, because by this module students are expected to be aware of what are the major sources, so that they should be able to identify the sources and analyzing it. So as regarding the sources of international environmental law, we have an immediate reference to a provision in the Statute of International Court of Justice, that is Article 38 Clause 1. Article 38(1) gives an indication of what kind of sources the International Court of Justice can rely on when they have to decide, when the court has to decide a case, or when the court has to identify a law, where can the court look into for sources. So in that way, Article 38 Clause 1 is generally regarded as the sources of general international law, and which is equally applicable in the case of international environmental law as well. So as per Article 38 Clause 1, the major sources of international law, or to rather international environmental law, are treaties, customs and general principles of law recognized by civilized nations. And another major source is judicial decisions and teachings of the most highly qualified publicists. But there is a qualification for the second source called judicial decisions and teachings of the most highly qualified publicists, because these sources are regarded as subsidiary sources. That means the first set of sources which I mentioned, that is treaties, customs and general principles of law recognized by civilized nations, these are considered as the primary sources of international law, and that makes judicial decisions and teachings as secondary sources. So we will briefly discuss what are the major treaties in the context of international environmental law, and how these customs are also relevant in the case of international environmental law. Treaties. So what is a treaty? To use a layman's kind of definition for treaties, treaties are legally binding agreements, and and in the context of international law, treaties are legally binding agreements between countries. There could be many kind of treaties. For example, treaties could be bilateral in nature, regional in nature, as well as or multilateral in nature. Bilateral means an agreement between two countries. Regional means an agreement between countries in a region. For example, if countries in South Asia come together and enter into an agreement, that can be called as a regional treaty. And multilateral means this is an agreement between countries from different regions, or it could also be called as a kind of global treaty, because it almost all states or several states are party to these agreements. So as far as treaties are concerned in the context of international environmental law, what we have seen is a proliferation of what we can call as a proliferation of multilateral environmental agreements since the 1970s. Multilateral environmental agreements means several countries from different regions, they entered into an agreement to address one or more environmental issues. So we will be identifying, or we will be discussing some of the major features of these multilateral environmental agreements with some examples. Let me first put some examples to get an idea of what are these treaties. For example, there is this treaty called Convention on International Trade in Endangered Species 1973, International Convention for the Prevention of Pollution from Ships 1973, Vienna Convention on Protection of the Ozone Layer 1985, Basel Convention on the Control of Transboundary Movements of Hazardous Wastes and Their Disposal 1989, Convention on Biological Diversity 1992. These are the few examples, and there are innumerable number of treaties relating to or in the context of or addressing different environmental issues. So we can let's try to identify some of the common features or approaches from these examples. We can see that all these multilateral environmental agreements, they are following a kind of issue based approach. All these treaties address a specific issue. Say for example, Convention on International Trade in Endangered Species, which is also known as CITES. It addresses a specific issue, or it regulates international trade in endangered species. It identifies a set of endangered species, and then it facilitates cooperation between its parties to regulate international trade, so that these species are these species do not get extincted. Similarly, the Ozone Layer Convention, Vienna Convention on Protection of the Ozone Layer 1985, and this also addresses a specific issue, and we can find innumerable number of examples, whether it is protection of wetlands or protection of migratory species, the issue of climate change, issue of transboundary air pollution, so on and so forth. So the essential characteristics is most of these treaty regimes, they address a specific issue. And the recent trend is, because last couple of decades, or at least since 1970s or 70s and 80s and 90s, we have seen a kind of proliferation of multilateral environmental agreements. A number of agreements have been adopted addressing different issues, ranging from wetlands to species to climate change to biodiversity and whatnot. But recently, of late, we have realized that mere adoption of international treaties or multilateral agreements is not sufficient. So recently, the shift has been changed significantly to the issue of implementation of existing treaties. So what we can say is, or what we can understand from this phenomenon is, the recent trend is not about adoption of different treaties. Instead, the recent trend is about how to ensure better implementation of existing treaties. So let us try to identify some common features of multilateral environmental agreements, because this module does not seek to give an elaborate description of each and every treaties, which is not possible. So what we are doing right now is to identify some of the common features of which we can see in almost all multilateral environmental agreements. An important feature is that all multilateral environmental agreements lay down obligations for state parties. Say for example, the Biodiversity Convention 1992, it lays down obligations to take measures for the protection of biodiversity. Another major important feature is it designs or envisages institutional mechanism for implementation of the treaty, because earlier many of these environmental treaties used to rely on existing environmental institutions. Say for example, several environmental treaties used or still using United Nations Environment Program as its institutional mechanism for implementation. But recently the trend has been changed, and nowadays multilateral environmental agreements are not using existing international organizations or institutional mechanism. Instead, they introduce, or recently these multilateral environmental agreements introduced a novel idea called Conference of Parties, which will come back to this issue or this phenomenon later. A third important feature is financial mechanism. Some of these multilateral environmental treaties introduces or envisages financial mechanism to facilitate or enhance the implementation of the treaty, or implementation of the rules envisaged under the treaty. For example, the Ozone Convention. Ozone Convention established a financial mechanism called Ozone Fund. The idea of this financial mechanism was to assist developing countries to meet their obligations under the convention as well as under the Montreal Protocol adopted as part of the convention. And the idea is majority of these environmental agreements, or look at the obligations which countries are supposed to fulfill under these environmental agreements, and it is quite clear that many of these obligations, if the countries want to fulfill these obligations, they require human resource, a lot of money and technology, which many of these developing countries are lacking, or especially these least developing countries do not have these facilities. So it is very important that all multilateral environmental agreements should have this kind of mechanism, so that all countries are able or capable of fulfilling their obligations. Otherwise, obligations will remain on paper, and this is one mechanism or one way to address the capability of state parties to fulfill their obligations under multilateral environmental agreements. The last important point is, what are the major advantages of multilateral environmental agreements? Why we have seen a certain explosion of multilateral agreements in the last 4 or 5 decades? So what was the major reason why we rely on multilateral environmental agreements to address our environmental issues? One important advantage is, this is state parties can come together and frame or adopt a treaty. So that means this actually ensures, or this facilitates, the ability of the international community to respond to emerging situations. First of all, majority of these environmental issues are uncertain and which requires significant scientific support. That means scientific evidences, or it requires first international community to understand what is the problem in the light of scientific evidences. So as and when the scientific evidences emerge, these multilateral environmental agreements equip the international community to address that issue without wasting too much time. This could be considered as an important advantage of multilateral environmental agreements in addressing environmental issues. The second one is, as I already mentioned this advantage, that it equips international community to respond to the emerging scientific evidences. Say for example, we still are not 100% sure about many of these environmental issues, including climate change. So our responses or the regulatory tools and regulatory measures should be according to the emerging scientific evidences or according to our latest understanding. So this multilateral environmental agreements and its flexibility, which enables international community to address these issues as and when they get, more and more scientific evidences, as and when the international community is and becomes more aware of these issues, its root causes and the possible alternatives or solutions.